Good evening, Pawan.
Very good afternoon, friends. I extend a very warm welcome to all our participants to the 160th webinar which we are holding today. You know, today's webinar is on a very current and important issue, which has become a cause of concern for particularly for companies which are listed on Calcutta Stock Exchange. The topic for discussion is Calcutta Stock Exchange resolving regulatory challenges in respect of freezing of promoters, directors, Demat accounts, and delisting of shares. Friends, as we all know, that recently Calcutta Stock Exchange has issued notices to all non-compliant companies as per the provisions of LODR regulations listed thereat that failed to submit their compliances and did not approach the Calcutta Stock Exchange for the revocation of suspension of their companies. Furthermore, the Calcutta Stock Exchange has also started resorting to compulsory delisting as well as freezing the Demat accounts of promoters, directors of such companies. And we all know what dire consequences are of compulsory delisting. With almost 1,100 notices issued by Calcutta Stock Exchange and freezing actions in respect of several companies having been initiated, the landscape has become very challenging and it calls for urgent resolution. The objective of today's webinar is to discuss the challenges and the practical solutions and strategies to navigate these regulatory actions. We have a galaxy of speakers today to delve into this issue. And it is my privilege to extend a very warm and hearty welcome to all our distinguished speakers. Our speakers are so distinguished and so well known to all of you that they hardly need any introduction. We have with us Shri Pramod Kumar Bindlish, who is a seasoned capital market regulator, having been former Chief General Manager of SEBI. He possesses over 42 years of experience, and during his tenure in SEBI, he headed several important departments. He has also been member of various committees constituted by SEBI, MCA, RBI, Ministry of Finance, ICSI, ICAI, etc. Presently, he is providing advice on securities laws and financial strategy. He is also sitting as independent director on boards of reputed companies. Friends, we'll also have the benefit of Shri Pawan Kumar Vijayji, founder, corporate professionals and past president, who in his own right is a very distinguished professional and has been navigating all our webinars. He will also join us and give his views on the subject. We have Ms. Anjali Agarwal, partner, head, capital market services, corporate professionals. She specializes in capital markets and is very well versed in SEBI and stock exchange related matters. We also have Mr. Ravi Prakash, who is associate partner, securities laws and corporate litigation, corporate professionals. Ravi specializes in representing clients in contentious regulatory proceedings, and it will really be, I'll be looking forward to hear his views on this very complex subject. Before I request Ms. Anjali to make her presentation on the subject, let me just inform all of you that our journey of webinars will continue, knowledge sharing will continue, and our next webinar will be held on 9th February, Friday from 4 p.m. to 6 p.m. on a very important topic, ESG, and will specifically deal with the topic revving up for business responsibility and sustainability reporting. May I now request Ms. Anjali Agarwal to make her presentation. Although I must put in record my appreciation for Anjali, although she is not well, still she agreed to participate and act as a speaker at our webinar. Over to you, Anjali.
Thank you so much, sir. Hello, friends. As VK sir said that I'm just to forgive me for not being able to switch on my camera. I'm not well. So just you will have to bear it this time. So before starting with my presentation on Calcutta Stock Exchange, as Sir just now said that the CSE has been issuing almost 1100 notices to various companies listed on the exchange. It has almost 1800 companies listed thereat, and it has issued 1600 such notices with almost 800 of them in the list of compulsory delisting. So one can imagine the type of chaos that must be created in the listed company's space as to receiving a compulsory delisting notice for being listed at Calcutta Stock Exchange or not being able to comply with any of the compliances thereat. So before beginning my presentation, I would just want to run you through the concept of regional stock exchanges that was prevalent. There was a time when there were almost 23 exchanges in the country. Presently, there are majorly 3 exchanges only, BSE, NSE, and MSCI. But there was a time when there were almost 23 exchanges in the country, almost 1 exchange per state. And why these were called regional stock exchanges, and why so many exchanges were there? Because there was this concept as initiated by SEBI or initially the controller of capital issues, that you have to mandatorily get listed at your home exchange. So meaning thereby, if your registered office is in Delhi, you have to mandatorily list on Delhi Stock Exchange. Rest other exchanges was the choice of the company. So if you are if your registered office is in Calcutta, you mandatorily were required to have your company listed at Calcutta Stock Exchange. So this is how the concept of regional stock exchanges got emanated. But over a period of time, and especially with the enunciation of online trading and BSE NSE being set up, BSE has been there for a very long time, but setting up of NSE in the year 2001, the concept of online trading came in, and all these regional exchanges virtually became defunct over a period of time. And by the year 2014-15, all the regional stock exchanges were de-recognized by SEBI. It was only Calcutta Stock Exchange, that too because some matter was sub judice. So the Calcutta Stock Exchange continued, and uh, there are news that Calcutta Stock Exchange is about to reinitiate its trading platform from March 2024. Let's see how it turns out to be. So now over to the journey of Calcutta Stock Exchange, because it's not a new exchange. It has been almost 200-year-old exchange and has been a pivotal exchange when we talk about the capital markets of the country. So it was started in the year 1830, and its own site says it that it was started under a neem tree. So one can understand how the concept must have been initiated. Then in the year 1863, they took a office premises on rent and initiated their trading. In the year 1908, it got the name Calcutta Stock Exchange Association Limited with mere 150 members. These members presently is almost 400 plus. In 1980, the central government gave it a recognition under the SCRA Act, and in the year 1997, they introduced a concept called C-Star, CSC, screen-based trading and reporting and digitization. They even initiated the digitized trading on their platform. But ever since, as I said, when everything was going on so well, why the Calcutta Stock Exchange or other regional exchanges start to decline? With the establishment of NSE, 1994 mein NSE got established. The trading at all the regional exchanges got reduced from a huge 45.6 to merely 8.4% of the trading volume. There used to be a concept of badla trading. It stopped in the year 2001. Even that was one of the reasons why regional exchanges came to a decline. Then initiation of the online trading, as I said, and Ketan Parikh scam in the year 2001. All these reasons clubbed together led to one after the other fall of all the regional exchanges, including the Calcutta Stock Exchange. Now, what about exit? When all other exchanges have been given an option to exit, what's the status of Calcutta? In the year 2008, SEBI issued guidelines to give an exit to all the regional stock exchanges, and whereby it was decided that any exchange having a turnover of less than 1,000 crores and a net worth of less than 100 crores, and it did not have a tie-up with any of the clearing corporation, was needed to voluntarily surrender their recognition to SEBI within a period of 2 years. While Calcutta Stock Exchange was able to meet the two requirements, but it could not establish a tie-up with the clearing corporation, and accordingly, it was asked to close their trading and halt the trading operations. Shivam? In the year 2011, CSC entered into a 5-year contract with NSE, thereby allowing its members to trade on NSE's platform, and the contract was automatically extended up to September 21. However, in 2020, SEBI questioned NSE as to the continuation of the agreement, and 2023 NSE terminated its trading agreement with the Calcutta Stock Exchange. And now Calcutta Stock Exchange, pursuant to a High Court bench, has vacated the interim stay on last year, 17th November. In fact, all the CSE shareholders have been asked to close all the transactions by November 28th, 2023. And that was the end of CSC's all trading operations. And it has been told to all the members that they have to either delist from the Calcutta Stock Exchange or take membership of NSE or as a NSE sub-broker. So there are 1842 companies listed. This number used to be almost 2,700 in the year 2010. So over a period of almost last 14 years, this number is reduced to almost half. There are 400 trading members, and in the year 22-23, the total revenue of the exchange was 17 crores, 17.88 crores, with a profit of mere 4 crores. So one can imagine that even the listed companies that were listed there because there was no trading being provided by the exchange, no trading had stopped almost in the year 2001, 2002. And then obviously when nobody is getting the benefit of the trading platform, the very purpose for which the exchange was set up, the companies decided to go in for delisting from the Calcutta Stock Exchange. Now, the present situation is that Calcutta Stock Exchange, for whatever reasons, I mean, it's a vicious circle when we talk about it. If the exchange is not providing the platform, companies stopped doing the compliances. Good or bad, right or wrong is not the question right now, but companies stopped doing the compliances, many of them. And now, all of a sudden, after so many years, Calcutta Stock Exchanges has started issuing notices to all these companies that either apply for revocation of suspension, or the exchange will be going ahead with freezing of the demat accounts of the promoters and directors, and ultimately will be going in for will putting in those companies in compulsory delisting list. Now, these are some of the numbers which are there on Calcutta's site only, that these many companies have been suspended over last 4-5 months. Now, when we talk about the listed arena, there are almost 9,000 listed companies in the country even as of now, with almost 6,000 being listed on BSE, 2,000 being listed on NSE, 1,800 something listed on Calcutta Stock Exchange. There can be and some 500 odd listed on MSCI. So there can be a scenario wherein a company is listed on BSE, NSE, Calcutta Stock Exchange, MSCI, but it is active on one of the exchanges, non-active on Calcutta, compliant on one of the exchanges, non-compliant on Calcutta. So we have tried to formulate some of the situations or some of the scenarios which which we have faced during last almost a month or so. So there can be a company which is listed only on Calcutta, exclusively Calcutta listed company. It is not listed on BSE, NSE. Even while being listed on Calcutta, there may be two scenarios, that maybe it is compliant or maybe it is not non-compliant thereat. Accordingly, its status would be suspended or not suspended at Calcutta. If you are a compliant company, you would not be suspended. But if you're a non-compliant company, your trading might have been suspended. The second scenario that might be there, that along with Calcutta Stock Exchange, Shiva, second scenario, second set of companies which are there are, along with Calcutta Stock Exchange, you are also listed on BSE, NSE. Now, this is a very critical, very difficult situation wherein my company is listed on BSE, NSE, and I'm a fully compliant company. I'm an actively traded company. But at Calcutta Stock Exchange, as I said, for reasons whatever, might be complying at Calcutta as well, or there may be a situation wherein I'm not doing any compliances at Calcutta Stock Exchange. If I'm a compliant company, I'll be an active company at Calcutta. But if I'm not doing the compliances thereat, my trading may be suspended or not yet suspended by the exchange. Situation 3, wherein I'm listed on BSE, NSE and CSE as well. At CSE, I am a non-compliant company. At BSE, I'm an active compliant company. Or if at BSE also I'm a non-compliant company and my trading is suspended even at BSE also, BSE or NSE as well. So meaning thereby I'm suspended at both BSE, NSE and Calcutta also. Situation 4, I'm listed at BSE, NSE or Calcutta as well. At Calcutta, I am suspended, I am non-compliant, but at BSE, I'm an active company. I'm not suspended at BSE. So in that scenario, there is a different permutation combination. Situation 5 that might arise is, I'm listed at BSE, NSE and CSE as well. I am listed on CSE, but I'm a non-compliant company there. At BSE, I am an active compliant company. Or if my trading is suspended, there is another set of companies which has been compulsorily delisted by BSE and transferred to dissemination board, but I'm continuing to remain listed on CSE. CSE has not yet delisted me, although as per the provisions of SEBI SCRA, rules, if a company is delisted from one exchange, if a company is compulsorily delisted from one exchange, it ought to be automatically compulsorily delisted from all other exchanges where I'm listed. So these are the scenarios. Now, what has happened in this 1100 notices which have gone by? All the set of companies have been put by CSE in the same bucket, as a result of which, whether you are listed on BSE, whether you are compliant at BSE, whether you are traded at BSE or NSE, and not being traded at Calcutta, not compliant at Calcutta, all the companies have been put under in one bucket. And irrespective of the fact that you are a actively traded company, and your uh, freezing of the promoters or demat accounts can have a amplifying effect for those promoters and directors. The trading is being the accounts, demat accounts have been frozen. So I think we need to deliberate upon the solution, possible solution to this entire scenario, by virtue of the elite speakers that we have today. Thank you so much, sir. Thank you. Over to you, Agarwal, sir. Agarwal, sir.
Thank you very much, Anjali, for giving a background of the regional stock exchanges and what led to their closure, and a historical background of Calcutta Stock Exchange and the various developments taking place. And very beautifully, you've come out with various scenarios which probably have been disregarded by Calcutta Stock Exchange while issuing notices. Perhaps Calcutta Stock Exchange has created a very paradoxical situation. No trading is happening, no service is being provided, but at the same time, they are issuing notices right and left. May I now request Shri B.K. Bindlish ji to enlighten us on this subject. Over to you,
Thank you.
Bindlish.
Thank you, Agarwal Sahab. Thank you, Pawan. Thank you, Anjali, and all the audience for this seminar. The issue which is being debated over here is of quite importance. Firstly, it is emerging out of the various regulatory steps taken by the SEBI for the protection of the interest of the investor in the exchanges where the note trading is taking place. As Andri had told that historically what has happened, that it was the need of the hour, especially in the late 80s, that in every state there need to be a stock exchange, because stock exchange is a place where you can raise the capital and effective optimum allocation of the resources can be made. So every state was having its own capital market. They were serving the needs of the local companies so that they can raise the capital of the smaller amount. Because if a company has to raise a small amount of the capital, it was very difficult for the company to go to the national exchange just like BSC or other bigger exchange. That important, the BSC was the big exchange. Ahmedabad Stock Exchange was a big exchange. Calcutta Stock Exchange was a big exchange. So this was a system was made out for that, and then the things were going on. But as you see, this technology goes on evolving. It is not a static thing. It increases. It new technology comes, and we have to modernize. And when this SEBI came into existence in 1992, it was very clear that we have to modernize our exchanges. Our capital market has to be modernized, and we have to adopt the technology for that part. And accordingly, the things started moving in that direction. And before that, if you see, the exchanges were becoming the clubs of the brokers. And investors' interest was at the least. Nobody cared about the investors' interest. So it was a deliberate move to set up a national exchange, which will be online and cater to the whole of the country. So due to that, the NSE came into existence, and the NSE was the first exchange which was given the jurisdiction all over India. Before that, regional stock exchanges were given the jurisdiction, which is limited to their area only. That if it is a Calcutta, they have a region to they have a region to West Bengal or something like that. After that, the BSC was also given the power that they can extend to the other areas. So once this kind of scenario happened, the relevance of the regional stock exchange came to a very, very challenging position, because when you get a better price discovery, the why investor will move to the regional stock exchange to place the order. He can very well do in the national exchanges. So things start evolving over a period of time, and the number of steps were taken so that the infrastructure which is available with these exchanges can be utilized, whether for the investor protection, for education purpose. So many steps were taken, and also to how because it's giving the employment to a lot of people, and a lot of brokers and other things are involved into that. Number of steps were taken, which Anjali has also narrated. But some of that I add on that the exchanges were allowed to have a MOU with the bigger exchange, BSC or NSE, so that their members can deal on that exchange platform of that exchange. Even the exchanges are allowed to have a subsidiary company, and which become the broker to the bigger exchange, and their member can trade on the platform of the bigger exchange, become a sub broker of that subsidiary company. Even the one experiment was made that interconnected stock exchange was made out, so that the number of regional stock exchanges come together and make one platform where they can pool their resources and compete with the national exchanges. But that concept has also failed. And along with that, the technology advancement and the products which become redundant, just when you're talking about the Badla, that has to be phased out, because we have to modernize our markets, the derivatives brought in that context. So they started dying. So trading was getting very, very less. In that scenario, the SEBI thought of that they should be now get out of the system if they are not able to serve the investor purpose. And the whole thing that happened, that if they are not having the 1,000 crore turnover or something like that, then they have to get out, and that process started. And initially there were some hiccups into that, but then we thought, okay, let them go out, and whatever the asset they are in, because the issue of the assets also, exchange got a lot of assets, the building, land, and infrastructure. Let you take over all the assets. We don't mind it, but you got exit and take care of the interest of the investor, and that went on going. The one or two exchanges put a resistance, but all come online in a due course. The CSC was one of the exchange which had not adhered to the thing. They said we will revive the trading, and then we said there is no issue. If you can comply with the conditions, you revive the trading. And the one of the condition was that you have to have connectivity with a clearing corporation to settle the trades. And settling the trade does not mean that just settle the guarantee of the trade, because the innovation in the clearing corporation is there. The guarantee of the trade should be there, which no clearing corporation, though clearing corporations are ready, BSC clearing corporation and NSE clearing also were ready to give a connectivity to the NSE, but they were not ready to guarantee the trades. So then we can this can't be happen, and then this CSC was told to stop the trading in that matter. They went to the court. And I understand that they lost in the court, and High Court upheld the order of the SEBI. But I don't know why at that stage itself the SEBI had not gone forward and said that you have lost the matter and now you should get exit. And I am now surprised to see that there was some agreement was between the NSE and CSC for allowing the platform of NSE to deal for the CSC broker to deal on that platform, now which got terminated, and now this High Court also put the seal on that final thing. It means that and CSC is no more a stock exchange. Now, what is the issue? What we are talking about the delisting of the companies, or they are issuing a notice to the companies. First of all, the very relevant question comes to my mind is whether CSC is still exchange. Somehow, I personally feel that SEBI should step into this matter now. That because they have the order of the SEBI as also upheld by the High Court, where the SEBI said that you have to exit. Now that this arrangement also been upheld by the Supreme Court, the termination of the agreement, so it is no more an exchange, and accordingly the thing should be looked into. that this is not an exchange, and let it be. All the companies listed over there should see that how they can protect the interest of the investors. And for that, the protection investors, the guidelines are already in place for that thing. I think the scenario which has been talked about by Anjali, I don't believe there is any issue with the company which are listed with the BSE and NSE, because the guideline is very clear that if you're listed on the national exchange, you can simply get delisted from the regional exchange. Nothing is required into that. They have just pass a resolution and tell the regional exchange that we are listed over there and we are getting out of the thing. So that should not be a big issue in my view, but they have to comply with which is not compliance be done. They can one-time compliance can be done. If some penalty is being got, some amount is paid for that compliance pay, that can be given, and the company can very well come out of it. It does not matter whether they're suspended at BSE or inactive at BSE. It's not a issue. If they're listed as BSE, though they may be suspended, they can very well do the delisting from the Calcutta stocks, and that can be taken care of. The problem comes, I don't know how many of the companies, 1100 companies mentioned, so 800 companies mentioned in the presentation, are they exclusively listed in Calcutta Stock Exchange? The issue is with the companies which are exclusively listed on the Calcutta Stock Exchange. So for those companies, there is a guidelines that are very clear that they can either get listed on the BSE or NSE. Even the BSE and NSE were directed that you lower your listing criteria to facilitate these kind of companies to come and get listed. And they were also told that you should do the hand holding for these companies so that they don't feel the problem and get listed. And if those companies which are not able to comply with the requirement of the listing or the regulatory listed requirement of BSE and NSE, then they have to move to the dissemination board. And in the dissemination board, now the quotes will be available, that what is the quotes are coming over there, but they will not be actively traded in the stock exchange platform. And within some period, they have to then get either listed or they have to get the exit from the dissemination board by making the offer, by buying the share of the investor. Some mechanism has to work out that they have to give the money to the investor so that they can get out of the system. So we have to see this issue not from just from the company's angle, but also from the angle of the investors who have put their money in these companies, which has become totally illiquid, and they have no way to realize their money. So these companies which are there, if they're suspended, they're non-compliant, their endeavor should be that how they can give the money back to their investors. And the valuation mechanism, I also mentioned the system, everything is there in that so that the investor interest is protected. See, to say from the angle of the companies only, I think may not be a desirable situation. If you will, these companies approach SEBI for that matter, the SEBI will certainly have this approach that what you are going to do about the investors who invested the money in your company. So that need to be seen from that angle also. And for the companies listed on BSE, there's no issue. They can just say that we are getting delisted from the Calcutta Stock Exchange, and they can move ahead. But companies need to certainly see that how they can protect the interest of the investor. And I feel that SEBI should also now, because the earlier order, I think 2013, the order was passed, and sometime 2016, 17 might have been upheld by the High Court. I don't know the date. So at the same time, on that time also itself, the SEBI should have. It was very desirable that the notice should have given to the further that you are exit from the system, so that the interest of the investors can be protected and the capital available can be utilized for a better purpose. So these companies, I'm not sure about what is the status of these companies, whether listed on BSE or not, because we're talking about 20, 30 companies which has notice has been given. So they should approach this seminar should become an opportunity that we can raise these issues before the SEBI as a feedback, so that they can take a call, because this is the only exchange left now. All other exchanges have exited, and because they were always they were the litigant in this matter. so that SEBI can take a call on this matter and quickly get resolved it before it spills over on the further, because 800 companies, we don't know how many companies they are going to give the notice now. Compliance may not be there. So, and as far as the freezing of the promoter and directors is concerned, security is concerned, that the freezing had to know the depositories. And the depositories should also be sensitized about this matter, that they should not blindly agree to the freezing of on the direction of the stock exchange, whose existence is still in doubt. That should also be need to, because these issues need to be raised to the SEBI so that SEBI can take a call. Because otherwise the exchange, which itself is non-compliant, which itself existence is in doubt, that whether legally they are exchange or not as of date, they say, okay, you freeze this exchange share or this promoter share or this director share. How to comply with the direction? Because we have seen in the case of the Karvi that now the SAT has come to this view that even the SEBI has given the order to the NSDL to return the shares, the pledged shares to the investors back. They called it a highway robbery. So in the same manner that if a exchange which itself is doubtful whether it is a legitimate exchange or not, to act on the recommendation of that exchange to freeze anybody's shares, I think depository need to be very, very cautious about that. And we can raise this issue with a suggestion to the SEBI that the depository can be sensitized about this issue and be careful while freezing the thing. In the meantime, companies have also to take step to be compliant and to take care of the interest of the investor. If they're listed on BSE NSE, you get delisted from Calcutta Stock Exchange. If you're exclusively on the Calcutta Stock Exchange, try to see that if you can get listed on the NSE or BSE, or you can, or they can go to MSCI also. That where are the lower standards of listings are there for that matter, or they can think of going to the dissemination board, so that at least something is available, some courses are available. If any want to exit, can exit over there, because interest of the investors also need to be seen. So I believe that this kind of suggestions and can help the situation, because the NSE, CSE is becoming rogue exchange. They are issuing the notices and this and that, and because they are still say they are the exchange. So this need to be first determined that whether it is still an exchange or not. So that need to be is a very, very important. Because exit is one thing, and whether it's exchange or not, that is a different thing. Only issue is that because the Calcutta Stock Exchange has got a permanent recognition. They have not got a year-wise recognition that after this year, this recognition is over. So the specific order has to come for that, your recognition is no more there. So this issue also, we have to flag that issues for the consideration of the regulator, so that the proper things can happen. But the sheer sympathy with the companies, I'm not agreeable to that point, that because investor interest also we have to take care of. And certainly I believe that when any issue will come to the SEBI notice, that will also one of the big factor while taking the decision. Thank you.
Thank you very much, Bindesh, for an excellent exposition of the subject and the bringing in the angle of investor protection to protect the interest of the investors, and how companies which are already listed on NSE or BSE, they should go about, and companies which are exclusively listed on Calcutta Stock Exchange, how they should go about. And whatever action is being taken, the interest of the investor should be supreme. It should be taken care of. And at the same time, feedback should be given to SEBI, and issues should be taken up with SEBI for appropriate action. And the question of permanent recognition given under SCRA also needs to be addressed. May I now request Pawanji to give his views on the subject. Over to you, Pawanji.
Thank you, Agarwal sir. Thank you. And Abendaleji, you have covered very nicely. I'm extremely sorry. I'm traveling, so that's why I'm not able to in the office. So the Kolkata Stock Exchange issue is very interesting. Interesting is that when I was studying as a student of capital market, I learned one word that what is a stock exchange? A stock exchange is a creator of liquidity. Now, how to create a liquidity? There are two aspects. One is they tell companies that I create a liquidity. So for their creating liquidity, they have a brokers. So broker do the trading, and because of their trading, the stock exchange providing liquidity to the company shares. Now, this is a basic fundamental point. If any stock exchange is not providing this service, then what is the purpose of the stock exchange? So first very important point which has come out, like recently SEBI has given instruction to all stock exchange that other than BSE, NSE, all stock exchange has to close it. And they provide exit opportunity to the shareholders, except Metropolitan Stock Exchange. And Calcutta Stock Exchange was also in the category of dying because they were also in the same category that they are doing. But because of some reason, some legal technical point of view, the Calcutta Stock Exchange never come out in this way that they are either died or they are alive. So because of this reason, the companies were not clear because Calcutta was not providing any trading. Calcutta has members were not doing any trading. They were having a membership connection with the NSE and they were providing through their subsidiary those who are the broker of the Calcutta Stock Exchange trading platform for their member just to trade, but they were not providing any services to the companies. Now they were silent. Their legal problem was going on. SEBI was also insisting that you close down, but they have not closed down, and they were doing so. Today, what is happening? Every company, because we have done a survey of various companies which are listed at Calcutta Stock Exchange, and they have received notices. They were saying that we were not aware the Calcutta Stock Exchange is alive. Now, this is a very serious point. If a company which was listed at Calcutta, which is listed at Calcutta, is not clear that the stock exchange is alive or not, that's a matter of concern, and stock exchange should see this. That is one part. Now, suddenly, what happened? The companies realize, because if you are listed in NSE or BSE only, then whatever information you want to give, it is just another email to Calcutta Stock Exchange you can send. But companies were not there. Company was not aware that Calcutta Stock Exchange is alive, so they were not sending. And they were not asking anything also. Suddenly what happened? Few months back, Calcutta sent a notice to various companies and they asked them to pay the fees, otherwise we will freeze your account. And then some companies which has not reacted, they have freeze their account also. Now, and then they were threatening that we will delist you. Now, there are two types of company. One is the stock exchange, Calcutta Stock Exchange listed only, or other stock exchange also. So if you're delisting from Calcutta Stock Exchange, it will not impact much. But if you are listed only on Calcutta Stock Exchange and you are sending a notice for delisting, it means the promoter's shareholding will freeze for a long term, and then 10 years he can't participate in the capital market. Now, this is very serious issue and very challenging. You cannot give the capital punishment to a company without their fault. So the way Calcutta Stock Exchange is sending notices, letters, threatening, and doing freezing also. We have received so many notices of our client companies. They were listed at Calcutta. Now their account is freeze. So they are coming, and now we are planning to go to SET. The point is, the SEBI has to come in this picture, and they should clarify the entire thing, whether Calcutta Stock Exchange is a stock exchange or not, whether if I'm not following something, then what is my punishment, and if they are freezing account, Bildeji has rightly pointed out that the NSDL, CDSL should not blindly follow this part. No doubt Calcutta is there. They should also resist, because you are not only freezing the promoter's account, company's account, and it has a repercussion. Okay, so this particular aspects is looked into this by SEBI, and they should come out with some solution. Okay, now the most important issue which is there, which I want to suggest to Calcutta Stock Exchange and companies also, Calcutta Stock Exchange should come out with some solution. The solution is that you tell companies that they can come out and they can come out with an amnesty scheme. And this amnesty scheme, they should provide a window to the companies that if you are listed at BSE, NSE, then you just pay a certain amount and you can delist from Calcutta Stock Exchange. One very interesting questions, Bindlesh sir, which has come out. Now, they have freezed the account of promoters in companies. And when they came to know that they sent a notice to the company, and the company had changed that registered office long back, because you are not supplying any information to the stock exchange. So they have sent a notice. Notice were undelivered, and then they have freeze. Now, Calcutta Stock Exchange, if they are doing this, they must release, because it's 1,100 companies or 1,400 companies. They can give an advertisement in the newspaper that these are the companies which are not doing, we have sent a notice, and if they are not replying us, we will delist them, we will penalize them, we will defreeze their account. So anybody and everybody can go there. It is just like if हम लोग ट्रैफिक पुलिस वाले को देखते हैं ना, कि वो कुछ लोग तो ट्रैफिक पुलिस वाले सामने खड़े होते हैं, जो जिससे इंटेंशन साफ है कि आपको वायलेशन को रोकना है. एक एक को छुप के खड़े हो जाते हैं कि आप क्रॉस करो और आई विल कैच होल्ड ऑफ यू. So I think this hide and seek game is going on, which is very harmful for the capital market also, for the companies also, and unnecessary we are creating a legal tangle and legal disputes, which is not desirable. So at last, I will just suggest that these are the very serious issues. You cannot defreeze, you cannot freeze any promoter's account. He has 5,000 crore rupees shares, 2,000 crore, 1,000, 100 crore, whatever it is. And his entire plan is disturbed. And he has to just see this, and there is a market going down, then he will lose money if he was not able to sell it. So first point which Bindleji has mentioned very rightly, NSDL and CDSL should not do this. They should send a notice from their side to the company that we have received a notice from Calcutta Stock Exchange, and this is what, if you want to do something, if you want to say something, you can say. By this process, what is the advantage? The letter can go to the correct place. Second point is that Calcutta Stock Exchange should give advertisement. Calcutta Stock Exchange should come out with amnesty scheme, because even if you are saying me that I should go and my company is suspended, so I have to remove the suspension. What I'll do after doing suspension? There's no advantage. You're not doing any trading, so I have to go for delisting from this stock exchange. So they should come out one-time solution, and they should also realize they should not do something arm twisting and taking advantage. These are my suggestions. Over to you, Agrawalji.
Thank you very much, Pawanji. Very well stated. In fact, Calcutta Stock Exchange had come out with an amnesty scheme a few years back. And I don't know why they have not again come out with a similar scheme now, when there is absolutely no trading and creating such a paradoxical situation for the companies, very odd situation for the companies. And as rightly said by Binglishji and Pawanji echoed it, that NSDL or CDSL, they should not take the instructions given by Calcutta Stock Exchange at face value. They should also intervene and take some steps or do something instead of just jumping and freezing the accounts of the directors and promoters, which have very serious consequences. May I now request our young budding advocate, Mr. Ravi Prakash, to give his views on the subject. Over to you, Ravi.
Thank you so much, sir. Because the matter arises out of a long and checkered history, it would be incumbent to refer to some of it, although the relevant parts have been taken up by Anjali ma'am and Bindlish sir as well. And then Pawan sir also, along with Bindlish sir, shed some light on how to go forward, how to deal with this situation, particularly for the companies which are listed otherwise on nationwide stock exchanges, and for those who are only and exclusively listed on CSE. These notices, which are the premise of today's program, which Calcutta has been sending out to the listed companies, they have started in couple of last months. And unfortunately, and this is quite surprising, that these notices do not even specify the barest minimum elements of casting an allegation or a shortcoming of fulfilling a compliance. One would, and I have a sample notice before me as I'm speaking, on which I have made quite a few markings. The notice does not specify an amount, although it says that some listing fee is due. It then proceeds to say that the annual listing fee to the exchange has not been paid for a considerable period of time, but no time period has been mentioned. Then it says that non-payment of annual listing fee is a violation of listing agreement, and instructs to pay 9% interest per annum for the number of years of outstanding annual listing fee. Now, the number of years have not been told. No account of services in respect of which this annual listing fee is being demanded is given. As a matter of fact, is that the legal battle between CSE and SEBI with respect to the compulsory exit process, which was launched pursuant to the committee headed by Mr. Bimal Jalan, was recommended that these regional stock exchanges should not be given exit to, because these infrastructure are anyway not contributing to liquidity. Therefore, you should consolidate the listed, and in view of the scams and manipulations that were happening, misusing these regional stock exchanges, and otherwise, they said that you now unify the regulatory framework, modify the regulatory framework for stock exchanges, and that led to the consolidation of stock exchanges into what we know today as nationwide stock exchanges, and then thereafter these exit were envisaged. Now, as I've already been said, that CSC then filed a writ petition, and thereafter a series of petitions or applications before High Court of Calcutta, so trying somehow to not get derecognized compulsorily by SEBI. But let me tell you how this all started. So first of all, when this Bimal Jalan committee report came out and this entire policy of exit by stock exchanges were being deliberated or being rolled out, SEBI exercised its powers and stopped the business of clearinghouse of Calcutta Stock Exchange, because they were not conforming to the regulatory requirement. It is surprising that they now today wants to punish listed companies for not conforming to the regulatory requirements with which they did not comply almost a decade back and have not been complying ever since then. So they were not non-compliant, and therefore SEBI did revoke their license to act as clearinghouse. Without a clearinghouse, exchange is like a tiger without teeth. So of course there could not be any trading, no settlement, and eventually, consequently, without sans a clearinghouse, they could not they could not achieve the turnover threshold of 1,000 crores, and ultimately led to the decision of compulsory exit from the status of a recognized stock exchange, against which they filed a petition. Initially, they did not have luck in the High Court, so they went to division bench. They got sort of a stay, and that decision is now reserved on 30th of November 2023. It could be a mere coincidence that ever since then, when this decision has been reserved by the Calcutta High Court Division Bench, these notices have started with more vigor and more speed, and it is now reaching out to every listed company which is listed at CSE. So it could be it could well be seen as an effort on part of Calcutta that in the interregnum, when they do not know whether the judgment will come in their favor or will sweep them out of the stock exchange business, they just want to collect whatever they can, because there is another issue of settlement guarantee fund, which they disclose in their annual report every year-on-year basis. So it does have a checkered history, but quite aside from the checkered history that this case has, one thing is very clear, that Calcutta Stock Exchange had been sleeping under a deep slumber for all these years. Now to suddenly come out of that and ask listed companies to comply, I don't think so. It can be achieved with the way Calcutta is proceeding currently. As I just indicated, that the letters that are being issued, those are full of typos. Well, that only reflect on how carelessly these have been issued. Secondly, they do not even give barest of details about the allegations that they are going to put. Now, let's suppose they are saying companies to pay the annual listing fee due with 9% interest. They ought to have provided the figure which the listed companies are being instructed to pay, the period for which filings have not been made, the communications to which they are referring to, and foremostly the services that have been rendered by them to these companies or to the investors in general. And on none of these counts, an answer or a clarification emerges from the correspondences that CSE is engaging with the companies in this entire episode. And then the last paragraph of the letter hurls a threat, essentially, that if you do not comply, freezing action is inevitable, and it will also lead to compulsory delisting. Well, I have my own doubts as to how this compulsory delisting will happen, because the regime of delisting, you see, and particularly in compulsory delisting, it has to follow certain procedural safeguards, because ultimately, for a listed company, compulsorily delisting is essential a ban from the listing regime, or it is akin to a civil death penalty for a listed company. The status of being listed goes away, and there are serious civil consequences and ramifications that are posed once the compulsory delisting is set into motion. And therefore, the legislature has provided quite a few safeguards. It does not, the language in compulsory delisting regulations does not only say that you have to hear. This is only one of the few legislations that says in words that you have to give a reasonable opportunity of being heard, considering the gravity of the action and the consequences it poses. But easier said than being done. It is written in the notices that compulsorily delisting will be enforced if they are not complying with this request. I am at pains to understand, if I was to receive such a notice, or I was a promoter of any such company, I would be at pains to understand what I am being asked to comply for. So therefore, the first step for these companies is to ask for relevant details from the stock exchange as to against what services and for what alleged violations and for what specific violations this letter has been issued and under which provisions. And thereafter, whether Because I remember this when I was reading the High Court orders, when SEBI started the process of exit for this very stock exchange, their prime challenge before the High Court was that SEBI did not form an opinion on the basis of which this entire exit was planned. Although that exit was not was specifically designed for Calcutta Stock Exchange, it was a general policy measure applied across all the regional stock exchanges. But that was one of the defense taken by Calcutta, that there is no opinion, and therefore without an opinion the entire exercise falls on its knees. Their own argument, I do not see that they comply with this in their own notices, because there is no opinion, there is no formation of an opinion, and the notices unfortunately are copy paste of each other in all the cases that I have seen. They suffer from the same omissions, same cryptic nature. Even if this notice is issued, I may say that I do not bear any doubt that no one who's the recipient of this notice would be in position to comply, because the notice does not inform the recipient sufficiently what they are expected to comply. So that is the first thing, as a matter of suggestion to CSE, that this specifics could be worked on, and companies and their officers and their management and promoters must be informed of what is expected from them, what they are being asked to comply. Secondly, it is for the recipients of these notices to take their matter with CSE and start a dialogue so as to arrive at a platform, at a discussion stage regarding what all violations are confirmed or what all violations they say that they deny with evidence that they have not committed. Thirdly, an even graver issue arises for the companies, those are not exclusively listed at Calcutta. They have their listings at some nationwide stock exchanges or both the nationwide stock exchanges. In those cases, I think the remedy would be to not only write to CSE, as Bindlish sir said, to also keep in loop SEBI, and if required, because these communications are akin to an order or an imminent threat that an order will be passed if you do not comply. So therefore, it may also be escalated at maybe in form of a writ petition, because as per the decision of Delhi High Court, a stock exchange is a public authority as per RTI. So therefore, because these do not have any reasons or rhyme, the notice is issued by CSE, one may contemplate approaching writ courts seeking that the CSE must be directed to come out with specifics and not act in an arbitrary manner. Or alternatively, this could be escalated through SEBI and SAT route in fit cases. Other concerns, so far as the investors are concerned, yes, I think the policy that SEBI made for companies which were regionally listed, that should also apply here. But for that also, the regulatory machinery need to work and clear out confusion on various issues, because that circular, I believe, has outlived its life already. That came or if at all that is living, then I don't think so there would be a need to come out with a new circular, but some clarifications need to be issued in the interest of investors as well. Now, for those companies, another aspect that is worth noting in these matters is the companies who had already applied to Calcutta Stock Exchanges, because in my personal discussion with a few cases, I was informed that people did apply to Calcutta long back for seeking voluntary delisting from this exchange, but they never received any response from Calcutta. In the course of reading for this program and otherwise for the cases, I scanned through the annual reports being filed by Calcutta Stock Exchange, and I found disclosures made by Calcutta Stock Exchange that year-on-year basis, they have been delisting the companies, both those companies who applied for voluntary delisting, and they had been also meting out compulsory delisting orders to certain companies. If that be the situation, how about the disclosure of cases which were applied by the companies for delisting and about which there is no status update, or those are pending disposal or consideration at the exchange level? Should these notices or these actions be contemplated for the companies who had already applied for voluntary delisting long back and which are pending consideration at the stock exchange level? That's another question that unfolds when we go further into the permutation and combination of disputes or issues that may be involved in such a matter. So that is, I think probably that is all from my side. I'll just quickly sum it up. One is the sudden coming up of Calcutta Stock Exchange from slumber and writing these letters to the companies without having regard to the facts and circumstances of each case, and writing same letter, almost the identical letter to every company, raising same issues, and the notices being suffering from same kind of vagueness, lack of information, and specificity. That's number one. Number two is that having no intelligible differentia for the kind of companies or cases that CSE must be encountering, painting everyone with the same brush. That's second. Third, as also espoused by Bindlish sir and Pavan sir, and initially by Anjali ma'am, is that what about the investors? How their interests are going to be protected if at all the Calcutta Stock Exchange is going to freeze the promoters or compulsorily delist the companies? And fifth is, what about the companies that had applied for voluntarily delisting to the Calcutta Stock Exchange and that no consideration or in more appropriately, no status update is given, or the process is not completed, neither rejected by the stock exchange? So for lack of any information being given in the public domain by the stock exchange, we say that those are pending disposal or consideration at the stock exchange level. So what about those cases? So these are quite a few issues that arise from this entire conundrum causing episode. And I feel these are only a few. We are probably only looking at the tip of the iceberg, because the more kind of cases we hear about or we receive, because people do have grievance regarding this. And I feel that because investors' fate is couched in the company, or because they hold ultimately the instrument of the company, it is, if the company is first protected, and therefore the entire gamut of delisting regulations were envisaged, if those are protected, if those safeguards are available to the company, investors are not going to suffer. But definitely, regulatory machinery need to be activated and look into this issue, because one on a case-to-case basis, Calcutta will deal with it. But I think there is need of some other policy measure, because the elephant is out, but this tail is hanging there. So some measure, some more inoculation is needed from SEBI's side, so that this issue can be resolved in an amicable manner, either through an amnesty scheme, which may be formulated by Calcutta, may be reviewed by SEBI and then rolled out for these companies. And there also intelligible differentiation needs to be applied, because these are not companies of same kind and flock and feather. They are all different. Some must be really operative companies. Some must be companies which are only existing on papers, and they do not really have any operations, or so to say, any functioning or economic activity today. So a policy need to be alive to the realities of these companies. An assessment of these companies need to be undertaken, and then accordingly options need to be laid out, and based on that, a policy should be rolled out. That's all from my side, sir.
Thank you very much, Ravi. Now it's time for the participants to raise their queries. I have already started receiving the queries. This is a very interesting query. Bindishji,
Yeah.
If the query is, if an SME company is listed exclusively on Calcutta Stock Exchange and current, it is having active status on Calcutta Stock Exchange. Now it wants to do a rights issue or offer for sale.
Yes.
Then, because to move to NSE, BSE, they say there are certain requirements of minimum number of shareholders and issued capital. So there is no clarity at all, and they are not in a position to increase their capital to meet the NSE, BSE norms. What should they do?
No, I don't feel there is any issue about that. It's very clear that to meet those norms, one can do the right issue and offer for sale. OFS is not there. You see, right issue is not going to increase the number of the shareholders. It may that some people may take the renunciation, this and that, but then it is not perceived that it will increase the number of shareholders. It may increase the capital. And OFS is nothing. OFS is the offloading of the share by the promoters or the other thing. They can do the preferential allotment also. They can do a preferential allotment, and because the guidance talked about all the things when the guidance came in 2012 or something like that, they talk about that thing that if such kind of companies are there, then they can make the preferential allotment and this and that, and even the BSE NSE will do the hand holding for that. So that is already provided into that, so the companies can do if they want to do it.
Thank you.
But they have to, what are the requirements of that? That has to process another thing that has to comply with. You have to be compliant with other requirements. You should not be a delinquent company. What are the requirements? That has to be complied, but they can make it. That's not a issue at all. SME does not, we see, go listed in the SME segment of the BSE, NSE. If you're just a SME company, you go and list on the BSE, NSE, SME segment. So you're complying with that. So that's also another solution.
The next query is
So may I also add?
Yes,
Yeah,
Anjali.
yeah.
Yes, please.
As told by Bindlish sir, yes, the company can come out with the rights issue or a preferential issue and thereby increase its capital or whatever requirements are needed so that it is eligible to get listed on BSE or NSE. So those modes are available and can do so at Calcutta Stock Exchange also.
Anjali, the issue is that the company says that they are unable to meet the
Exactly. So for
CBS.
example, to
That's
be
a different
able
issue.
to get listed under the direct listing route at NSE, you need to have a capital of 10 crore. This company is having might be having a capital of 3 crores, say. So they will have to come out with any of the further allotments, increase the capital to 10 and become eligible to get listed on BSE or NSE.
What I
And
would suggest is
what I understand their query is this only, that they are not able to get to do so at Calcutta. Can they do so at Calcutta, basically?
yeah, they can do it at Calcutta.
They can do it.
They can do it at Calcutta, and I will suggest that you go list in the SME segment, na? Then after 2 years or so, you graduate to the main board. If some issues are coming in raising the capital, then that is also route available.
Mr. Bagaria can contact me. I can help them.
Thank you, Anjali. Thank you.
Yeah.
The next question is for Ravi, although Ravi, you answered this question, but still there is a query from one of our participants. They say our company had already applied for delisting in 2003 and no action has been taken by NSE. And after 20 years, they are asking for fee and revocation process.
Well, then, in such a case, these facts must be brought out before CSE. And if they do not hear anything from CSE or there is no response absolutely, which which already have complained that they are not receiving any response despite writing. In fact, no phones are picked and absolutely no response, then they have to escalate it to a legal forum. It could be SEBI, but I have my own doubts whether SEBI can exercise jurisdiction here when especially a matter is sub judice and judgment is reserved. Certainly, SAT would then become a forum for agitating these issues. But there also we need to see, because an order only can be challenged before the SAT. So we need to see which order we are going to challenge. Writ, certainly, because this notice, this communication has come, and because these exchanges are considered to be a public authority so far as RTI Act is concerned, and because they are, we have adopted the approach of self-regulatory organization for stock exchanges, and they're not just intermediaries, they're market infrastructure institutions.
Yeah.
So therefore, they ought to bear some responsibility for their conduct, and therefore a writ may be filed, and these questions must be, I mean, they must be brought to the book for raising these kind of issues after 20 years, and at least some clarification will flow. Some accountability will be held at CSE's head for these actions. I think those actions can be explored by the companies who feel aggrieved, really genuinely aggrieved by these actions.
Thank you, Ravi. One of our participants is given, it's not a question, rather a comment. Is SEBI aware about the whole matter? SEBI must intervene and stop CSE immediately.
Varsi, I feel something must be going on, certainly.
Yes, certainly.
Because generally, it's not that these things remain hidden. And some action might be flowing in. I don't know, but certainly it should be, something should be there.
One of our participants says that we send our local person to Calcutta Stock Exchange and they asked us to send the email. Still no reply of email, and they do not pick up the phone.
This is nobody can respond to this. Right?
There is another question. Anjali, if a company has complied and is active throughout only in Calcutta Stock Exchange with no economic activity, is there any way out for delisting in this scenario?
The company can, what I am understanding from the question is it is exclusively Calcutta listed company and is a fully compliant company. Yes, the company can go in for delisting after following the procedures as given in the delisting regulations, depending upon whether it's a reverse book building case or a small delisting case.
Firstly, I will suggest Agarwal Sahab that if the company don't have any economic activity and they don't have a plan for starting economic activity, they must go for delisting.
Delisting.
If they don't have any plan to go for economic activity, this is just a skeleton company.
Correct. Correct. So I think delisting is an answer.
Yeah.
That is the way out. There is another question from an independent director. He says, I am an independent non-executive director. Does this freeze impact me differently from the whole-time directors?
Freezing actions are being taken against all the directors, sir. In fact, all the regulations which talk about freezing, they talk about the freezing of promoters and promoter group.
Yeah.
Nowhere freezing of directors' demat
Director is
accounts is there. I don't know where from is the director's demat account freezing is coming in, but it is happening.
But Anjali, in the notices being issued and the instructions they have given to the depositories, they have said directors also.
Yes, exactly. That's what I'm saying. But neither the delisting regulations nor the SEBI SOP circulars talk about the freezing of directors' demat accounts. I don't know where from directors' demat accounts are coming into picture.
Even in the letters, they are saying what will be the consequences of compulsory delisting. They are threatening of the freezing of all the directors' accounts.
In case of compulsory delisting, if a company is compulsorily delisted, then the directors and the KMPs cannot act as directors of a listed company for a period of 10 years. But even there, freezing is not mentioned.
Right. Ravi, any different view?
No, absolutely same view. It's all conjured up in thin air. There's no legal backing in that. This is what these companies are fraught with. Unfortunately, this letter is, there is a word legally, you call it cryptic. If there was an even more superlative degree of word available in English dictionary, that must be used for this. This does not tell anything.
No, you are sending a illegal notice sort of thing that you are threatening for the action which action is not permissible under law.
Yes, absolutely, sir.
Bindilshi, a question for you. How investors of companies listed only at Calcutta Stock Exchange how do they get liquidity? Can their trading be done in other stock exchanges be allowed?
For that, they need to list. See, there are two mechanisms of that a stock can get traded on the stock exchange. One is through the system of the listing that is listed on that exchange, then they can trade over that place. That's a normal thing. Other permitted securities. At times, what happens that suppose a stock is not listed on an exchange, but the members want that they should be trading should be there, then under permitted securities, this can be allowed. So there are only two mechanisms are there. Otherwise, without listing, you cannot get liquidity in the other exchange.
No, but
that's not possible.
Sir, this action will have to be initiated by the company.
Company. You see, company exchange also at time.
What would
exchange also. Earlier, what used to happen, let me tell you, that some companies were listed BSE only, or some companies were listed at suppose Calcutta only, but they're not listed BSE because they don't have any interest. But member of the BSE want that company should be traded over here. So they will include then the permitted securities and trading will take place over there. But no disclosure will be made to the BSE by that company because there's no agreement between that company and the exchange. So, but because these kind of companies which are on the CSE, they have to look for that they get listed at NSE or BSE so that the investor interest can be taken care of. If the management is really thinking of protecting the interest of the investor, they should take the positive steps instead of negative steps. They should go and list if some compliance is required, capital is less, okay, you issue the further capital, this and that, and try to see that investor interest is protected. But first of all, that should be the underlying theme of the thought process of the company.
Ravi, there is another query for you. I am listed in NSE and BSE, applied for voluntary delisting in 2003. Not paid listing fee since no compliance done. Now we have not received any letter. It is just seen by somebody on the site. They freeze the Demat accounts.
Oh, so they've not even received any letter.
Yes.
Again, they should again reason it out with Calcutta Stock Exchange. But I'm sure if they approach, they will be told that you pay first and then talk about defreezing. Well, again, they'll have to seek legal recourse. But as Bindli sir says, that the foundational mindset has to be of bringing it to a resolution. One cannot just go and take a head-on clash with CSE and ask for waiver of fee, because ultimately, if anyone approaches court or any regulatory authority, they will be asked to first prove that they did not incur these non-compliances for which CSE is alleging them. So that burden they'll have to discharge in their case. It is a different matter that one may attack CSE that the CSE does not have any leg of its own to stand on, but that may not completely exonerate them from there discharging their burden of proof, which is to showcase how you were managing your compliances. So I think this is a double-edged sword, certainly. I mean, they must write frankly to CSC, pointing out all what they can in merits as well as in law. And then if they do not see the situation getting resolved, then escalate it probably. Consult a legal practitioner and take your appropriate remedies. Those are available to you.
Right.
But Ravi, in
Yes.
this case, I'm a BSc NSC listed company. I'm a fully compliant company doing all the compliances, payment of fee, etc. But Calcutta, I have not done anything because the reason may be that I was not getting any facilities, trading facilities. The reason may be the company secretary did not even think, okay, we are listed on Calcutta, and did not do it. So in that scenario, freezing of the Demat account of such a company, freezing of directors or promoters Demat accounts of such a company is really it's a big step.
It is certainly without even issuing a notice. That certainly is. But unfortunately, since freezing has already been made effective, the only option is to reason it out with CSE, and which I feel would meet the same fate as Sir has been telling us regarding the other queries. It would also meet the same fate, and therefore I see that they will have no other option but to take it up with SEBI or SAT or a writ court, whichever way they wish to go, after evaluating the facts of their case and the stage at which they are. Unfortunately, that is how it will be, because there is in Indian system of law, the cardinal and cherished principle is that an order might be bad, an action of an authority might be bad, but it has to be reversed in accordance with law by a higher authority which has jurisdiction. Someone may not say that, oh, because this action is bad or the order is bad, I will stand defiant to that order or action. That unfortunately is not recognized in our jurisprudence. Therefore, they'll have to toil and go through this process. Unfortunately, that is how it is.
Thank you, Ravi. Anjali, they want one participant wants reconfirmation. Can CSC freeze any director's Demat account or only promoters' Demat accounts?
So what we have seen, they have issuing notices for freezing of directors' Demat accounts as well. Whether promoters or non-promoters, they have not considered. They have not considered that. So even directors' Demat accounts are being frozen.
There is again a comment. It's not a question. Is when company is not able to trade. What is the use of CSC? I think the same thing what Binji sir said. Does it really exist?
Yeah, this is a serious issue. I'm telling you, this is a serious issue which SEBI should look into, that whether it is still an exchange. Because the exchange got a lot of powers. Because the first level regulator, they got a lot of powers. With the company, with the investor, with the intermediaries, they have a lot of powers. And if somebody want to misuse those powers, that can cause havoc, which they are now creating. This is a serious issue.
Definitely, sir, because the very, very odd and very difficult situations have been created for companies and company promoters, directors. Anjali, there is a question. Ravi, you want to say something?
Yes, I just wanted to highlight another interesting aspect here, and I would request Bindlish sir to also shed light and guide us on this. See, the judgment has been reserved in this matter, where it will be decided whether CSC was rightfully exited by SEBI or it can continue as a stock exchange. In the run-up from this reservation of the judgment till the actual pronouncement, which is likely to happen soon, why CSC is so much, so much active and going after all these companies? What if the What if they collect all these dues and then ultimately the judgment comes that, yeah, the decision of SEBI was right. They ought to have exited back in 2013 or whenever they were given first exit. What will be the fate of the monies deposited with CSC? How will, or should at all, from governance point of view, should CSC at all initiate all these processes when the judgment is yet to be pronounced on the fate of its exchange status? That is also another thing. Bindish sir, I think we will be really enlightened by your views.
I agree with you, but seeing the whole conduct of the CSC, do you expect them to meet the standards of corporate governance or the governance? This is the conduct of the exchange. You
Right.
see, they're very clear that they are not doing any trading since 2013.
Yes.
After that, to contest that legally that we are exchanged
Hmm.
and you're not complying with the conditions for being exchanged,
Correct.
that is also the conduct. And
Right.
that also, I'm sorry to say that also when the 50% board members are the independent directors nominated by the SEBI. I
Yes.
don't know after that they have nominated or not. I'm not sure about that thing. In that scenario, even that scenario, when the SEBI gave the order to contest that order, I don't know how because I personally talked to the this independent director at the point of time. Okay, why you're taking this decision? You are the nominee of virtually the public interest, and the regulator has passed an order without understanding the implication of that. You are just going ahead with the filing the case and contesting in the court. So that itself was a conduct issue. You see, and if the CSC would have behaved in a proper conduct, I think things should have been different.
Right.
From the day when their conduct was not proper, since the 2001 that the things happened over there, the Ketan Parekh and the outside Badala and this and that, the conduct was always in question.
Hmm.
I say you will not be aware that president of the Calcutta Stock Exchange at the time was jailed also.
Oh.
So what I'm saying, a conduct issue is there. They're not. They're not right now also coming to understand that thing. Your conduct that matters. So even you get an order, okay, you can act as exchange. They will never allow it. I'm telling you.
Hmm.
So you can't meet the conditions.
Correct.
So what will happen? So there's exercise futility. Or
Yeah.
what do they get? What the people are getting out of that? That you are harassing the people, other people, this and that. This is sadistic pleasure, nothing more than that. So it's a conduct issue. They should not behave in this manner, and they should gracefully exit.
Absolutely.
The order, personally, I feel the order will be in favor of SEBI only.
Hmm.
If other things are not taken into consideration, because it is simple, you're not complying with the conditions. The laid down process is there, laid down conditions are there, not complying with that.
Yes.
So
And
and we are now talking about that we become a developed country, and then we are dealing with this kind of issue, which is immaterial, which does not make any sense virtually. So my view is that they should conduct in a graceful manner and stop all these kind of things, all the notices, and sit together with the company that how better we can move these companies out of the Calcutta Stock Exchange, and investor interest is protected in that manner.
absolutely.
That should be the approach.
I think that will be the win-win situation.
Yeah.
Thank you so much, sir.
Thank you. Now there is a question both for Anjali and Ravi. Practical guidance they want. How to deal with the freezing of PAN or Demat accounts of directors.
Ravi, over to you.
I will have to repeat myself again. If the freezing has already been
Yes,
meted
it has
out,
been done. Accounts have been frozen.
accounts have been frozen, then certainly, first of all, the reasons must be asked from CSC. That should be the first step. If the freezing has been done without any letter or without any notice being sent to you, or without any opportunity being afforded, a letter must be written seeking reasons as to why this freezing has been imposed. After that, an inquiry needs to be taken up by the company and at its own level to find out whatever reason is being supplied by CSC to check the veracity of those reasons, and to both on merits as well as in law, and thereafter making a full-blown representation to the stock exchanges and also seek some interim press from them. if you feel that your request has fallen on deaf ears, then please escalate it through the appropriate legal forums, which could be SAT, SEBI, number one SEBI, or then SAT, or parallelly you may approach writ courts for redressing your issues.
Ravi, the next question is, how can they freeze Demat account of company secretary and compliance officer? As the list provided by Calcutta Stock Exchange on their website for freezing of account of promoters and directors, CS name is also mentioned over there.
Well, first thing, it has already been done. Now your question, how they can do it, is
They have done it.
See, they have done it. First is that. Second is that you'll have to reason that out before the appropriate forums, how they can do it. Yes, so far as your question is concerned, it is unfortunately not legally permissible to defreeze the accounts of compliance officer. To freeze the accounts of compliance officer. I do not know, and I do not know of any such provision under which this could have been done. But you see, arbitrariness knows no limit. And they are acting arbitrarily. As I told you, the notices are, in cases where notices have been sent, those are also very cryptic. So yes, you will have to, unfortunately, that is the situation. You will have to make a representation and take your legal safeguards if they have already freezed. But before you escalate it to any superior legal forum, I think my suggestion to the person concerned who has raised this query would be to write a detailed representation to Calcutta Stock Exchange, one asking them relevant questions about and including this question that you asked us, under which provision you have frozen my accounts, and then delineating your response to and your role with respect to the company. It could be the case that you resigned from this company long back, you are working for since long from somewhere else, the records are not updated, still you have been frozen. Point out all of that to Calcutta Stock Exchange. And I feel if your request is reasonable, it should prevail. If it does not, then please escalate your grievances to an appropriate forum, including SEBI.
There is again another observation. As there is no contact point, the company and the directors are suffering.
I'm telling you that is a conduct issue. That you don't have any person who can attend to the query. Nobody respond to the query. You go issuing the orders. The one side. So that is a very serious matter, and SEBI should take it very seriously. This kind of conduct from the exchange. I don't know whether SEBI has conducted the inspection of, because they don't recognize the exchange. They might have conducted an inspection also because no trading is there since long. It may be.
Now, would SEBI consider this, that Calcutta is impersonating itself as an exchange and sending out letters?
No,
now?
really, this is a valid. I'm not very serious on that. This is a very valid question.
Yes, yes.
Whether CSE the exchange.
Of course,
So
of course.
That is very serious question. That because exchange means, as per the law, they have got the power of the state.
Yes.
In the Delhi Stock Exchange case, they have court has decided that there is the power of the state.
Right.
So you cannot behave in this manner, that arbitrarily you are issuing the notices without giving a proper thing, and then that is a serious matter. SEBI need to take this into account. Because you take up this matter, we send a letter to SEBI with all suggestions, etc. And SEBI must be aware, and I believe that they must be contemplating some thing in this matter.
There is a practical issue. Ravi says a company formed in 1982. We had delisted around 1990, but the promoter director had passed away. We have the ROC annual return, which has only 5 shareholders, thereby proving that the delisting must have been done. We do not have the papers of 1990, but we have received the notice from CSC. What can we do? Ravi, the same reply?
Oh, I think this is because
this is a different case. Yeah.
it comes with indication of some facts. So a different reply. But yes, overall the same strategy. You should point this all of this out to stock exchange CSE, and rather seeking records in your own at your own place. You should ask CSE to put records that how do they consider you being listed with them. If you say that you got delisted and you have a paper in which only 5 shareholders are being shown, then please ask CSE to clarify on what basis they are considering you listed with them, and why after so much time. And then put all your points, all your submissions before CSE, including, please do not forget to mention a request for stay or interim relief so far as defreezing of the accounts are concerned.
But Ravi, along with that, they must to definitely check their annual returns that they file, that they've been filing with the ROC, as to how the number of shareholders has reduced to 5, because only 5 shareholders does not necessarily mean that the company has been delisted. I have seen cases wherein there have been 7, 10, 15 shareholders only. Still, the company is a listed company. So you will have to see your annual returns, whether at any point in time you had 100 shareholders, which got reduced to 5 only. So then that may form a basis of discussing the matter further with Calcutta Stock Exchange.
There is the next question. In 2003, the company was listed in 4 exchanges: Ahmedabad, Bombay, Delhi, and Calcutta. The voluntary delisting was filed with all the 4 exchanges. All exchanges approved the delisting except Calcutta Stock Exchange. The company had followed up till the next 6-7 years, that is till 2011, and the same was apprised with SEBI also in 2008. Now, defreezing of all the directors, IDs, NEDs have resigned due to this. While visiting Calcutta office multiple times, we have been outrightly informed to pay the outstanding dues. Then only they will defreeze directors' Demat accounts.
Virtually, what I understand, they are saying they have filed for delisting with all the 4 exchanges. It means they wanted the delisting with all the exchanges. Then the reverse book building process might have been done. They're talking 2003. In that, reverse book building process was there. So I'm not sure whether what they're writing is correct or not, because the 3 exchanges will not. CSC might be the regional stock exchange for that company at that point of time.
Correct.
That may be the reason the other exchanges allowed and CSC has not allowed the delisting, because reverse book building has to be done. So I don't know, we don't know the facts of the case, so we cannot comment, but that may be the thing, that what process was adopted for voluntary delisting at that point of time. So if you don't adhere to that process, then it remains listed at CSC.
The next query is NSDL mail received says, this is to inform you that in accordance with SEBI circular number so and so, Girija Industrial Promotion Limited, dated January 5, 2024, and so, freeze Calcutta level suspended, client level suspended for debits has been executed in following beneficial ownership account. How do I get these circulars, and as they have not been shared with me?
Public domain, the circular in the public domain. You can Google it and put the circular name and it will come.
Yes, I think.
So this is also related to Calcutta Stock Exchange, or it is otherwise? This question, I'm not sure.
This is for Calcutta Stock Exchange, yes.
So this kind of notices are being received from NSDL CTSL by many
Okay.
companies
Mm-hmm.
that pursuant to CSC letter dated dash.
Okay.
Yeah. Client
Okay.
BOs being
Okay.
debited.
Girija Industrial Promotion Limited is the company name.
Yeah.
And why they are referring to SEBI circular, and then this? I think they have not used it properly over here. That it will be SEBI reference to SEBI circular, and then the reference may be the company name. Okay.
If company is listed on BSE and complying with all the provisions, and the company is not aware about NSE existence,
CSC,
now,
CSC, not NSE, huh?
Demat account of promoter freeze. The first we have to apply for revocation and then for delisting of CSC, despite of the fact that we never mentioned even in our annual reports about this CSC.
But sir, this stand may not be very correct. See, in the prospectus, it must have been mentioned at what all places you are going to get listed post the IPO. So
Yeah.
you must be aware, you or your any of the earlier people in the organization, that you are listed on CSC, but over a period of time, you stopped mentioning it as a different aspect. But to saying that we are not aware of our listing at CSC is not the right statement. So the company will have to approach Calcutta Stock Exchange asking as to the way out, because we are a BSE listed company. So asking for any sort of waivers, they will have to do that.
Now, again, a question from investor. Some of the investors have invested in the shares of company listed on Calcutta Stock Exchange. The withdrawal of trading by BSE is not allowing the investors to liquidate the shares. What should the investor do?
No, I don't
So,
think BSE allows the trading of the stocks of listed at CSC in the platform. They only provide a facility of trading by the CSC members
Correct.
on the stocks listed at BSE. That was a system earlier in the BSE which has stopped. That they will separate platform was there where the regional stocks and stocks will be dealt with. But there was an issue doing that was closed. So I don't feel that query itself is appropriate. Because there is no such platform is there now BSE that where the regional stocks and stocks can be traded. And that happened long back that BSE was asked not to give this kind of facility.
yeah,
Long back.
that Indonext
Indonext,
sort of,
yes,
yeah,
Indonext. That was
yeah.
closed down long
That
back.
was long back,
Long back.
yeah.
Freezing of
I cannot remember the name. It is Indonext. Indonext.
Freezing of Demat accounts will cause loss to shareholders. How shareholders who is not made any mistake be protected? I think this is very.
No, sir, Demat account is being frozen of only the promoters and
Only
the
the
directors.
promoter.
Yeah. Well, that's
Public,
sure, not
public
shareholder, not
Not the
shareholders,
shareholder.
yeah,
Not the
they are
shareholder.
not,
No.
they're
Ravi, which route shall be most expedient? SEBI, SAT, or RIT?
In all cases, first they must write to CSC. And so far as choice between SEBI, SAT, and RIT court is concerned, SEBI is no match of SAT or RIT court. One is the appellate body of SEBI, and RIT court is with respect to the fetters. If someone is putting constitutional fetter or impinging on your fundamental rights, then you go there. So it depends on the facts of your case. It is not that all three options are available at your disposal. Only if you qualify for filing a writ petition, if you have such a cause, then you go for writ. And if you have got an order, suppose they have frozen your accounts, that's an order of freezing. That is an appealable order. You can go there. But if it is only a notice which asks you to show cause or to comply with certain requirements, then you can't go to SAT. So it really depends on at what stage you are, what is the difficulty you are fraught with. That will determine which forum you'll have to go. But in all such cases, I think it will be safe to say that you can at least write to CSC. And because SEBI is the securities market regulator, you can also mark them copy or draw their attention to this issue.
Right. Now the Demat accounts are freezed. Then the CS approached, and he was told that there is no benefit unless you pay first. Even before going to SAT, they will have to pay outstanding dues. And Calcutta is not even trading.
I think the understanding that if they
Yes.
go to SAT, they will have to pay first is not correct.
It's not right. It's not
It's
right.
not income tax tribunal that you'll have to
Yeah,
deposit
yeah.
5%.
Yes.
That's not the case.
What if a company decides to provide an exit route to its investors? Can Calcutta Stock Exchange still withhold defreezing accounts?
So that means they want to give a delisting offer.
Yes.
So post the delisting offer, they will defreeze. Before delisting offer seems difficult. Else the routes suggested by Ravi are followed.
Right. Now, this question is not clear further, sir. Delisting applied in 2003. Now share capital increased. Will they ask for increased capital?
I don't know what is the question.
A
I
question.
think that is a
I'll
follow-up
tell you.
question.
I'll
Someone
tell
asked-
you
Yeah.
this question. So,
Yes.
so presuming in 2003, when the company applied for delisting, the capital of the company that was listed was 10 crore. And now the company is listed on BSE and NSE as well, and the capital is 20 crores. So listing fee would be on the basis of 10 crores or 20 crores, because capital listed at Calcutta Stock Exchange is only 10 crore. This is what I'm understanding from what is written in this question.
Right.
There is a case which one has to discuss individually. This can't be
Yeah,
with the
these
all
things,
full
yeah.
facts. One can suggest anything. Before that, it is very speculative and does not serve any purpose. And next is very interesting.
Next is very interesting.
Very interesting.
Calcutta Stock Exchange is also freeze demat account of wife of one of the directors. Can they do so? What can be done? Ravi?
If she is the part of the promoter group, certainly.
Yes.
Yeah, she must be a part of the promoter group,
Promoter
then
group.
only it can happen. Otherwise, it cannot.
Yes, I think this has been answered. She would fall in promoter group, and therefore those remedies need to be
Yes.
available.
Now, I think the no more queries. We have answered all the queries. And now to sum up, I think as is the tradition, we'll start with Bindlishi. 1 minute, your concluding remarks, sir.
My concluding remark will be that this is the issue which is emerging out of the exchange which is not providing any service, and all these issues need to be highlighted before the regulator for a policy as well as enforcement response, because these issues individually taken up is not going to help any manner. And if from this forum some suggestion goes to the SEBI, certainly I believe that there will be policy response also, and enforcement response will also be there, and some relief certainly will come out. Thank you.
Thank you. Anjali?
Sir, my last concluding remark would be that Calcutta should seriously think of coming out with some sort of amnesty scheme for the listing fee areas as well as for the penalties that are proposed to be imposed on the companies, because the type of queries that have come up are by and large dealing with the matter that the company was non-compliant at Calcutta. And that means at least a crore of rupee penalty would be there on the basis of present SOP fines. So Calcutta should come out with some sort of amnesty scheme.
Ravi?
Yes, sir. Sir, I feel that the way these actions are being taken by Calcutta Stock Exchange, these will only, unfortunately, will not only increase the burden for Calcutta Stock Exchange, because they does not seem to be bothered. People are writing to them, visiting them, they're not seem to be bothered. This is only going to increase the ongoing and already heavy burden of the institutions and regulatory authorities, including certain courts. And this could be easily avoided by the suggestions given by Bindlish sir and Anjali ma'am. See, they're not going to head anywhere with these kind of notices. That's number one. Secondly, the question of conduct or the issue of conduct that Bindlish highlighted, that is very much there. If you see, right since beginning, their conduct is in question. They have been going to courts. They have got orders, adverse orders. At some instances, they got some stay in their favor. But I think that final leg is also, the final order is also awaited now, being reserved. So I think that clarity will also come. All said and done, sir, the way this is being proceeded with is not going to head anywhere rather than causing a lot of confusion, and more than the confusion, lot of unwarranted consequences for people and investors. This all can be avoided if Calcutta is ready to heed to the sincere and I must say enlightening advice given by Bindish sir, Anjali ma'am, and Pawan sir. And also experts are writing on day-to-day basis at various forums. So I think all of that must be considered by the exchange, and they must, if they want to recover some dues which are legitimate and they have the capability to recover, or those dues are really owed by people to them, they must follow the due process of law. This is not the way that merely because you have the keys, you lock the Demat account of people and then you'll take them on ransom, calling for money. That's not the way. That's as I think sir mentioned something called highway robbery. That's not the way. So I think this is the takeaway. They should follow the process of law, even if they want to take action against these companies. And you never know, sir. Tomorrow we are doing program this Friday. Next Friday the order comes, says Calcutta Stock Exchange. What is going to happen with these reasons and all? You never know.
Thank you very much. Thank you, Bindish sir, Anjali, Pawan sir, Ravi, for extra. I think we have threadbare discussed the various nuances, and if the participants still have some queries, I think our experts will be too glad to help them out with their answers. Please write to us at Corporate Professionals, and we will reply each and every query. And if any query has not been answered completely, please let us know. We assure you all your queries will be answered and replied appropriately. And friends, thank you all for joining us and making this such a vibrant webinar. Our journey of knowledge sharing will continue, and we meet again on next Friday, that is the 9th of February, from 4 p.m. to 6 p.m. and on a very important topic of ESG, and the aspect of ESG which we propose to cover is revving up for business responsibility and sustainability reporting. So look forward to another fruitful academic and intellectual discussion on 9th of February. Thank you very much, one and all. Thank you.
Thank you.
Thank you.
Thank you. Thank you all. Thank you.